A federal court has blocked Texas from using a redrawn U.S. House map in next year's midterm elections. It's the same map that sparked a nationwide redistricting battle. Yesterday, a panel of federal judges ruled 2-1 and argued that the state's unusual redrawing would harm Black and Hispanic voters.
The decision comes amid a national battle over redistricting. North Carolina and Missouri followed Texas, making new maps and adding an additional Republican seat each at President Trump's request. But to counter that, California voters approved a ballot initiative to give Democrats 5 more seats there. Texas Governor Greg Abbott vowed a swift appeal to the U.S. Supreme Court and to defend his state's map.
We want to bring back in Queen City News Chief Legal Analyst Khalif Rhodes to talk about this. Khalif, what do you make of this ruling, and what could the broader implications be in other cases? Because in several different states, you can make the argument that these areas are based off of race and not just political people trying to get more seats for their party.
Yeah, this is, if you've been tracking this for a long time, the writing has been on the wall, and I have been watching this, so I'll go back a couple of years. The case is already in the Supreme Court. The state of Louisiana has been attempting to maneuver and shift around seats, and the Supreme and other courts have told them they can't do it the way they wanted to because race was at the central factor. The Supreme Court is deciding this case now. Clarence Thomas has made it his case to say that he wants to address that specific issue, talking about this Voting Rights Act in Section 2 that requires that you don't have not just a racial intent in redrawing maps, but a racial impact. And that's something that he wants to address and he wants to take out of there at any means that he can. So that's the baseline of where we started. And then you got to go to Texas. Texas starts to do this redrawing of the maps because President Trump wants to try to find ways to secure the majority in the House and in the Congress. And what do? They go out there and draw maps that the court said likely have been racially gerrymandered. And then Governor Abbott comes back and says that, no, these maps were done and they reflect the state's conservative voting preferences. These judges are relying on the evidence that was supported and submitted before them, and Governor Abbott now says that they will immediately appeal this to the Supreme Court, which I think may give them a look at it, stacking on top of it with the Louisiana case. In response to all of that, California does something completely different and doesn't use their General Assembly, but lets the people decide on a constitutional amendment measure, and that is something where we're at now. And then North Carolina, deciding not to be left out of the dance, decides that, okay, we also can redraw maps. Don Davis's district in North Carolina's House 1 is the one now, and that's going to be in the crosshairs as well with a hearing this week. And so anytime you're talking about drawing maps, anytime there are census, you're going to have an opportunity to draw, redraw, and now litigate maps. And that's something that I've come to expect over the last maybe 15 to 20 years.
North Carolina is more of a kind of 50-50 purple state, right? Governor doesn't really have a say when it comes to this. We've got a Republican majority in the North Carolina Supreme Court. If this goes to the Supreme Court, where do you see this going in the final decision?
The Texas case, if it makes it to the Supreme Court, it's a 50-50 shot. It's much like the makeup of our state. I think it will boil down to Chief Justice Roberts, in deciding how he wants his legacy of his court to be left and dictated. While he may attempt to say that you set that aside and you look at every individual case, if you decide this Texas case and the Louisiana case and erode the Voting Rights Act and things like that, what it took to put those in place, you will have a mark on your legacy, for better or for worse, that says that you have removed 40 to 50 years of work that it took to get to that point.
Okay, and real quickly here, California, this was a voter referendum and they approved it. How was that? It cannot be challenged too? Or is it a lot harder?
It can be challenged, but
okay.
It's something that will be significantly harder. General Assembly moves, legislative moves can be challenged on an unconstitutional basis. A vote by the people will be really hard to say was unconstitutional because it wasn't a group of people sitting in the room. This was all the voters' constituents in the state that voted and support this by overwhelming support. Not saying that it could not be challenged, but it would be historically and significantly harder to challenge.
Okay. Chief Legal Analyst Khalif Rhodes, thanks for breaking that down for us.
Queen City News Plus. Just search Queen City News on your smart TV's app store.